Thank you everyone for tuning in again. My name is Elizabeth with the San Diego County Bar's Lawyer Referral and Information Service. And we are glad to be here today with one of our panelists, our attorney, Traci Hoppes. And she will be discussing family law, a little bit more specific in the area of child support and spousal support. And, what she's seeing currently, everyone coming back to the courts and trying to run as smooth as possible after COVID. So we'll go ahead and go with introductions and then we'll dive into the first question. So Michelle?
Hi, my name is Michelle Chavez. I'm the Director of Public Services at the San Diego County Bar. And I'm super pleased to have Traci Hoppes here to discuss family law issues that we're seeing, that we're getting a lot of calls and requests for attorneys. So thank you so much.
I'm happy to be here. I am Traci Hoppes. I am a family law attorney. I'm a certified family law specialist, and our law firm here is the law and mediation firm of Kluick and Hoppes. I've been practicing law since 1992, almost exclusively in family law.
Oh, wonderful. Thank you so much. So I'm going to start with the first question. Because of COVID, is child support services still enforcing existing orders at this time?
Yes, children still need support, even during COVID. Most people continue to have employment. If there's been a change in someone's income because of COVID, if they've maybe lost their job or have a reduction in income, then they need to file a request to modify their current support orders. Existing orders don't automatically change just because of COVID.
Okay, thank you so much.
And in order to file for child support or spousal support, is there a filing fee with the courts? And because of, the pandemic and all of that, is there a fee waiver possibly for people that can't afford the filing fees, or how does that work?
Well, yes and yes, there is a filing fee. So if you have an existing court order, perhaps from a divorce judgment or a petition for paternity, and you need to change that because you've lost your job due to COVID or something like that, to file a request in family court costs $60 for the filing fee, plus an additional $30 for a mandatory court reporter fee, so it's $90. And if you're at a point where even $90 is something that would be a huge stretch for you, you've lost your job, then yes, there is a fee waiver. And the fee waiver application is something that you can find on the court website. You just need to meet certain income levels. And if you're below those levels, then you can apply for and be approved for a fee waiver. If, on the other hand, you're somebody that's trying to access the Department of Child Support Services to assist you, then they would not charge a filing fee.
Okay, so let's say that I'm employed, or I was employed, and either I've been furloughed, I've been laid off, or I've been, the business, where I worked went out of business, and I'm receiving unemployment benefits. But I'm also ordered to pay child and spousal support. Can they will child support services garnish my unemployment fees? Or how does that work? How do I pay that later in life? And after I'm fully employed?
Well, that's a good question. As to whether they would garnish your unemployment, I've honestly never seen that happen, but they could. The order remains in place. But what you should really do if you've lost your job and so now you're on unemployment, the first thing you need to do is to file a request to modify your support. Again, it just doesn't automatically happen. You know, sometimes people will reach a deal with their ex or the other parent, and they'll say, yeah, I know you're out of a job. It's okay. Don't worry about it. And then, a year or two on down the road, that person might say, hey, you owe me arrears for all those times you didn't pay. And that's true because the order remains in place. And so it's really important that if you have a change in your income, a change in the amount of time you're seeing the child, a change in anything that would affect your child support order, that you file a request to modify it, and don't just rely on you know, an email or a handshake and a nod. You need an actual court order to show that while you're out of that job and on unemployment, the order should be reduced.
So can I do this modification on my own, or do I need to hire an attorney? Is it a form? You know, how does that work?
Yeah. Well, sure, people can do it on their own, or sometimes you need an attorney to file a request to modify. You need to file what's called a request for order, and there are the forms are on the court website. There's also the court buildings offer somebody that will help you with paperwork. It's called the Family Law Facilitator. When it's not COVID, you can actually go to the courthouse and meet with a facilitator. Nowadays, you'd have to go on the court website. I believe there's phone appointments and clinics and other ways that you can access some help with that. Those people will help you to fill out the paperwork. They will not later appear for you in court or help you strategize the way an attorney would be. But if it's a fairly, you know, straightforward request, I lost my job, I'm making less money, you know, you can file that on your own. Once it's important just to get it filed, because at least then you're preserving your request. Each month that goes by that you don't file it, the existing order remains in effect.
Would I have to pay that back later once I'm gainfully employed?
Yes, if the existing order is in place and you have not modified it and it has not been changed, and if you're not paying it, then those payments that you're not paying are called arrears, support arrears. And the bad thing about support arrears is that they also accrue interest at the legal rate, and the legal rate is 10%. So it's a lot. So it's never a good idea to get behind on paying your child support. You don't just want to stick your head in the sand and say, listen, I can't afford to pay this, I'm just not going to pay it, because the arrears are going to add up and you're going to owe interest on those things. So again, that's why if you really can't pay it, the first thing you want to do is to file a request to modify.
Okay, thank you so much.
And just to clarify, the $90 filing fee that you mentioned earlier, was that for a modification, or does that also apply for an initial, you know, submission of support?
Yeah, that's a really good question, Elizabeth. That was assuming that somebody has an existing order. If you don't have an order at all and you've never had any orders in family court, then you need to, in order to access the courts, in order to get some kind of an order, you need to file a petition. If you were married, if you're married and you want to get a divorce, then you file a petition for a dissolution. If you were never married, you file a petition to establish a parental relationship. Either of those types of actions can get you access to the family court. So now you can get orders for support, for custody, for whatever you might need. The initial filing fee is quite a bit higher. It's currently $435. And then once you've done that initial first paper filing fee, any requests for orders that you make, whether to modify or for an initial order, then that's that additional $90. Mm-hmm. But of course, remember, like we said, there are fee waivers that you can sometimes qualify for if you meet the income requirements.
How long does it usually take for the fee waiver to be approved or denied?
It's fast. They'll set a time and they'll approve it. And sometimes what happens is they may approve it fairly quickly, but then later on in the case, you'll get a job or the court will find out that you had maybe some money they didn't know about. So they might order you to pay that back, but you can get an order sometimes that $435 fee perhaps could be paid back at $25 a month or $50 a month, something like that. So the courts, they're always hurting for money and they want to get their fees where they can. But on the other hand, you know, getting kids child support is really important. And so they will grant a fee waiver fairly quickly if you need it.
Okay, great.
Thank you. So I'll jump into the next question. So is there a limit on how many times someone can file for a modification? Sometimes, you know, parents just don't get along and they just change things constantly? Like, does the court limit that, or can you just keep taking it to court?
That's a good question. There's no like limit on the number of times you can request a modification, but there does need to be some kind of a change in circumstances. You can't just get angry and go to court every month. That's not going to work. You need to have a change. So the three factors that come into play when setting a guideline child support formula, or also in spousal support, is number one, your incomes, how much does each parent or each spouse make. Number two is your time share with the child. The more time you spend with the child, the less you pay in support. The reasoning going that, while you're with the child, you're spending money on them. You're maybe having to keep an extra room, for them, things like that. And the third main factor is your tax filing status, because that affects the amount of net income you have. So if your income changes, if the amount of time you spend with the child changes, if your tax filing changes, even some other things like your health insurance deduction, if all of a sudden maybe your employer was providing you with free health insurance and now all of a sudden you're finding yourself paying $600 a month in health insurance, that affects your income. Anytime something like that changes, you can file a request to modify. And that's appropriate, and you should do that.
Awesome, thank you.
All right. So what if, let's say that I'm, the person who's supposed to be paying the child support, and I'm just not that great at doing it, and I get behind on my payments, and, my wages are not garnished, and, I do it on the honor system. And so, let's say that I'm in arrears. How do I deal with that? Can I get an attorney to help me to, either come back and say, you know what, I actually, lost my job during that period and I never told you, I ignored it. How does that work? And, is it just like, nope, you owe this, da, 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 now you're going to pay interest? Is there some sort of, process where this person can get caught up and stuff like that?
Yeah, that's a good question. And so there are a couple, 2-3 things an attorney can do to help that person. One would be to find out, like, well, exactly how much are the arrears? Maybe there's a question between the parties about when payments were made and when they weren't and what was due. So we can help come up with what the exact amount is. And then, yeah, that is owed, and it doesn't just go away, and you can't discharge it in bankruptcy, none of those things. But what we can do, and what I've done many, many, many times for people, is one thing you can do is to try to negotiate. Maybe the other side will be like, listen, I know you were having trouble, or I know you don't have that money. If you just give me this much, I'll settle. Maybe they'll do that.
Sort of, yeah.
Yeah, you can come up with a kind of an agreement and just sort of settle on something. Another thing you can do is set up a payment plan that says, listen, I know I'm behind, in $10,000. There's just no way. I don't have $10,000. I can't give that to you. But hey, I just got a new job, and I'll tell you what, I'll pay you an extra $100 a month on top of support to help go toward those arrears. So there's a lot of things you can do. Even if you owe money to the Department of Child Support Services, which is sometimes the trickiest thing because they're going to charge that interest and they're not going to go away, they even have programs. There's a compromise of arrears program that I've used with clients before that you can even sometimes work out a deal with them. So it's always worth, contacting an experienced attorney. We can, and we will be honest with you and tell you if we can help you or not.
So I have a follow-up question to that. There's two of them. One is, if we make this agreement, let's say I owe you $10,000 and you say, okay, I'm going to pay you $1,000 extra a month, say I have a whole ton of kids, I don't know. And, should you have this put in writing? How do you document it? So it's like, yes, I did pay you that money back. It's not just word of mouth. Do you need an attorney to draw up something, or what can you do?
Okay, good question. Yes, put it in writing, and not only put it in writing, but it should be filed with the court as a stipulated order. It doesn't mean anything. It doesn't mean anything unless it's filed with the court. I don't care if I sometimes will have people that will say, listen, we went to a notary, we wrote this down and we notarized it. It doesn't mean anything. It has to be a stipulation filed with the court. It's best to get an attorney to do that because there is certain language you want to put in there. You don't want to go to all this work of coming up with an agreement with somebody. And if you can't afford to hire an attorney to do everything for you on that, maybe you can just pay them for an hour or two of their time to help make sure that your agreement is drafted correctly and filed with the court. I think it is important because, again, it doesn't mean anything unless it's filed with the court.
Okay, great. And I have one more question. So, let's say that my wages are garnished or I'm behind on my child support. I know there's things that will happen that the Department of Child Support can do, like I think maybe I can't have a passport, or there's certain things that if you don't pay your child's support or your spouse's support, that can happen to you. Can you inform our audience, on what that could be?
That's right. That's again another really good reason why it's serious to take care of this. Some child support orders are just through the family court. Others, a lot of them are being enforced through the Department of Child Support Services. As a government agency, they have the power to do things that as just a private attorney, I can't do. They can hold your passport. They can hold your driver's license. They can take your tax refund. They can do a lot of things that are going to make you unhappy until that's paid. So it's rather than just waiting for those type of things to happen, I think it's better to be proactive. And as soon as you know you're getting behind, if it's because you lost your job or some other good reason, file that motion to modify. If it's just, maybe I was being a little irresponsible, I got a little bit behind, jump on it, get some sort of an arrangement in place to get caught up on the arrears, or see if the other party will forgive them, or, if you owe $10,000, say, listen, if I just give you $5,000, can we call it good? And they say, yeah. So then again, you write it up as a stipulation, you get everybody to sign it, and then, that's done. So otherwise you're looking at, next time you want to, you're expecting that nice big tax refund, you find out, oh, wait a minute, I didn't get it. The Department of Child Support Services took it. So nobody wants that to happen.
Right. So it's better just to be proactive. Don't wait. Don't hide your head in the sand, and try and figure out the best way to, make your payments. If it's $20 a month, $1,000, whatever it is, because it's going to catch up with you.
Absolutely. It does not go away. It's one of those things that's just always going to be there. And an attorney can help you to deal with that. We're there to help.
Okay, thank you.
So tying into the next question, you as an attorney, when would you recommend someone to contact an attorney? Sometimes, people try to do it themselves and then they find themselves lost in the process, or, family law could be very emotional as well and draining. So, is it best to just contact an attorney from the start to kind of see where they can take it or how they can help? Or also, if people might think it's too late, if they went through the process themselves and now they're in this mess, and then they're like, well, I don't know if I should contact an attorney. What do you suggest?
Well, the two favorite words I think of any attorney is it depends. It's all facts driven. If maybe you've been to court a couple times before and you've been through this, and now your job's just changing again, and you're a W-2, salaried person, and so is the other parent. You can do it kind of on your own through the court. But anytime you have any questions, or if it's complicated or you're not sure what you're doing, it's obviously always best to use an attorney, because otherwise, I've seen it time and time again. People do it on their own. Even sometimes people that hire just a paralegal, it's not done correctly. And then it's much more costly and difficult to undo something, than it would have been to just do it right the first time. Anytime there's more complicating factors, like if somebody owns a small business or you think they're lying about how much money they make, and maybe you need to do a little bit of discovery to find out what their real income is, those are things that it's really hard to do on your own, and it's best to get the help of a professional.
Okay, great. So let's say I decide, you know what, I need to get help. I'm $50,000 behind in arrears. There's no way I can pay, and I haven't done the modification. What should I have? What should I prepare before I contact the attorney or I have my first meeting? What would be really helpful for you as an attorney to have?
Well, that's a great question. First of all, don't feel bad about doing that, because that happens all the time. I get contacted by a lot of people that owe arrears, and you're certainly not alone. The things that I would want to see are, number one, what's the current order? When was it made? If you have a copy of the court order that says, what is the custody arrangement or what is the support order that you were supposed to be making, that's number one. Number two, I want to know what your income is. So if you have copies of your pay stubs or your last year's taxes, if you're a small business owner, if you have a profit and loss statement, maybe the Schedule C from your tax return, anything that's going to show what you actually make. And then thirdly, if you have it, information on what the other side makes. You're going to have that from whatever the last court order was, if you have a court order. If not, maybe you used to file taxes with them. Maybe you have a copy of an old pay stub of theirs. Whatever you have, bring it in. I'd rather have more information than less, because then what I'm able to do is I have a software program on my computer that's pretty much the same thing that a judge would have in the courtroom, and I can run what a support calculation would be, and tell you, number one, if you should modify or not, or if it's an arrears program, we can decide, what's the next best step? How can we deal with this?
Okay, great. Thank you.
And then another question that kind of ties into that is, how are people filing these days with the courts? And is the court open to the public? Can someone just say, I need to file this child support or spousal support, I'm going to walk into the courthouse? Or how are, if you're representing a client, how are you guys doing it?
Well, the courts are open. But they are not open in that you cannot walk into them. So for what the San Diego courts were closed during the initial, pandemic COVID closure that everybody had. They opened up a little bit after the last Memorial Day. And one of the things, there's two ways you can file right now. Obviously, if you hire an attorney, we're going to do it for you, don't worry. But the San Diego court system did enact an electronic filing in family court, so we can e-file now. You do need to be signed up through an e-filing service, so we can handle that. You can also still file it at the courthouse on the outside. They have drop boxes where you can drop off things if you want to file them. Initially, there was quite a backup and everything was really, really delayed, but they're getting more up to date now. It's a little bit more, normal as much as it can be. We're getting used to it. There's still court hearings. If you can't come to an agreement before your hearing, they're taking place virtually. We do it just like a Zoom meeting. It's called Microsoft Teams. And the court website is very helpful. It has a lot of information there. If anybody listening to this hasn't gone to the court website, just Google San Diego Superior Court, and it'll probably be the first thing that pops up. And there's a lot of valuable information on there that tells you how you can file and how things are going right now.
Okay, thank you so much for that information. I think we are about ready to wrap up. And I think this is really valuable information for anyone who has a child support or spousal support either issue or, you know, or just wants some basic information, we're so happy you were able to answer some of these questions for us.
Anytime. Thank you so much for asking me.
Thank you again. And for anyone watching this video, Traci is part of the lawyer referral service. So we thank her for being part of our family law panel. And you know, if you are in need of an attorney or you want to just speak to an attorney regarding your particular issue, you can call the lawyer referral service. We are open Monday through Friday, 8 a.m. to 4:30 p.m. And just this year, we also started the 24/7 referral system, which allows people to get a referral 24/7. So please visit our website and contact us directly. So we're here to help. Thank you, everyone. And thank you again, Ms. Hoppes.